So first of all, we'll have Fraz, and he's going to be talking to you about wills generally, why you need one, what kind of wills there are, and the kind of things that need to go into one. So pay attention there. Then we'll have Basit, who's going to talk to you about trusts and different types of structures. Followed by that, we're going to have Seema. She's going to be talking to you about the taxation implications when it comes to wills and inheritance. We've all heard about the dreaded inheritance tax liability, something that everybody wants to try and kind of limit as best as possible. And then we're going to have Sheikh Haitham, who's going to be talking to you about Sharia law and its application to Shari'ah Wills. So once all of that is done, you'll then get your questions to ask. You'll get the opportunity to ask your questions. Throughout this event, you can use the chat box option at the bottom of your screens, and you can insert your questions in there, address them to Saracens solicitors, and put whatever your question is in there, and we'll receive those. And if you want to speak to our experts live, just mention it when you do send that post to us so that we know. Alternatively, if you want to speak to our advisors, you can also raise your hand. You also have that option. So whatever you prefer, chat box or raise your hand. So now first up, we're going to talk to our experts, and they're going to tell you a little bit about what they do. We have Fraz from Saracens Solicitors next.
Good evening. Thank you, Kajal, and assalamu alaikum to everyone that's logged in today. I think we've now got a handle on getting everyone mute, but if you can keep yourself muted, it will allow for everyone's enjoyment of their listening. So just a little quick introduction about me. I'm a partner at Saracens Solicitors, and I have been qualified for 20 years, right? I don't know where the time has gone. And I was one of the founders of Saracens Solicitors that set up in 2005. So we've been running 15 years. And today, I'm going to be talking to you about wills, right? And I'm going to spend about 5 minutes. I can't educate you on everything on wills, but the critical thing here is to understand the legal nature and in its with the Sharia, okay? So first and foremost, a will is a legal document, okay? And as I mentioned before, you're all on here now wanting to hear about Sharia wills, but the interaction with English law is critical because the document is invalid unless it is governed and correctly drafted and executed in English law, okay? When we're putting together a will, there are some key components to it, right? And I'm just going to now touch on each one of those because I've only got about 5 minutes. And then I'm going to invite everyone that has any questions to raise those questions specific. So the first thing you do when you've got a will, you've got to identify yourself, right? So there's a clear statement as to who you are and the date of that will, and also a revocation, meaning a cancellation of any previous will. So that way it takes away any confusion or conflict between the current will document and anything you may have drafted in the past. Okay. Now, the difference between an English will and a Sharia will, you don't need to have a declaration of faith in an English legal will. In a Sharia will, you would do that, and you would also cite, your funeral or your burial arrangements. Okay, and you may want to go into detail. I'm not going to go into that now because the Sheikh will do that in a bit. But for an English legal, for a will to be valid in English law, there first needs to be somebody that will undertake the administration of the estate when you pass away. That person is known as executor. Okay, and we would always recommend that you would have 2 executors as opposed to 1. In case one of them passes away during, predeceases you, it does not then invalidate the will. It goes without saying, right? You'd have someone that's trustworthy, someone that would follow your instructions, and there is a legal responsibility upon them, right? Now, when we talk about wills, when we consider a will, most of us want to consider what do we own and how do we distribute it, and that's valid, right? Under the Sharia, it is predetermined as to the distribution of those assets, and the Sheikh again will talk about that. But it's important in the will to identify what those assets are, because you're no longer there to speak for it, and therefore you need to identify what those assets are. Some of them are obvious, right? For example, property, but then you have sort of bank accounts and things like that, right? You'd want to identify that for your executor, so it's easy for them. One of the critical reasons why you would want to detail all of your assets is also an interplay with tax, right? In order to make the estate tax efficient, you would want to first identify those assets. And then if you are over the threshold amount, which is currently set at 325,000, you would then speak to one of the tax guys in order to then possibly rearrange the assets, the ownership of those assets, or possibly set up trusts and what have you, in order to make the estate efficient. So identifying those assets is not just a simple case of just having them so that they're listed, but it's also so that we can then work out from a tax perspective whether we can make the will more efficient. With regards to asset ownership, just very quickly, a lot of us are married and a lot of us own a property and most of our wealth is parked in that property, right? Now, the default position in ownership of joint property is a legal phrase known as joint tenants, okay? And if that's the case, then if you wanted a Sharia will, you would need to rearrange that ownership, severing that joint tenancy, so changing that ownership from joint tenancy to tenants in common. And the reason for that is because if you own your property jointly as joint tenants, and it's recorded that way at the land registry, that position overrides whatever you put in your will. Now, under the Sharia, you would want to distribute in accordance with the tenets of the Quran, right? Whereas if you've got ownership of a property as joint tenants, so that would override that, which would then cause a conflict between the distribution of the assets and what you said in the will. Okay, so just one of those aspects. So I'm conscious I'm running out of time. You would want to consider, again, with regards to property, if you're married, to avoid causing hardship to the surviving spouse, you would want to consider some sort of trust arrangement whereby the surviving spouse is able to hold on trust the balance of that property during their lifetime. Because quite often, without that in place, if you were to distribute the assets, it may even result in having to refinance the property or sell the property in order to realise the funds that then are able to be distributed in accordance with the will. To avoid that issue, you would build a trust within the will itself and allow the surviving spouse to hold on to that asset. And I'm sure Basit and Seema are going to go a little bit more detail in regards to trusts. If you have kids, you need to consider guardianship, obvious, parental control to avoid the kids falling into the social system. You would also, I always say to people that this is your last instruction, right? It's not uncommon for people to leave a message, let's say, within the will. And also, I would think about things like, for example, charitable donations within the will. You would cite those. Again, the Sheikh will talk about that in Sadaqah. And also, finally, we live in a technical age, right? It's often forgotten, but a lot of our details are now withheld on passwords or on platforms accessible through passwords. So you may want to cite your passwords in your will. I know my wife is particularly interested in that one. So it's a consideration, right? Now, finally, the thing I wanted to kind of highlight a little bit on is the execution of the will. The will itself, for it to be valid, needs to be signed by the person making the will and witnessed by two other people in their presence, right? Which basically means there is a document that's then signed, wet ink signature, and it has two other people that have seen that person sign it, also sign it at the same time. Now, in this environment, social distancing in the lockdown, that's causing a problem. And the law is 250 years old, and they are talking about changing it. But at this present moment in time, that's the position. So in order for the will to be valid, it needs to be signed by the testator or the testatrix, the person making the will, and witnessed by two people. I have seen innovative ways of that being able to take effect, allowing for social distancing. People popping the will underneath a windscreen wiper, let's say meeting at a petrol station or a car park, holding that will underneath a windscreen wiper, signing and then rotating in a trio so that way the will was validly executed. I've heard that if you are particularly vulnerable and you can't get out of the house, let's say, because of your underlying condition, that you would possibly, at the door on your side of the property, sign in front of a window and then post through a letterbox, and then the other two witnesses will be there and again countersigning and then post the will back. And if you can't do that, then I'm not suggesting that this would be valid, but I would say that you would at least sign that will if you're on your own, and maybe video film it and then send that video to somebody so there's evidence of it being validly executed. That's the valid legal requirement, and the reason it's there is really for your protection. At a time in the 18th century where people, didn't have the level of sophistication, they would do a thumbprint, that they would need two people to witness that. So I would think about the way in which you would execute it. I've talked way over my time, so I'm going to hand back to Kajal. I'm surprised she didn't interrupt me until now. Thank you for listening, guys. I'm available to take questions at the end of the presentation.
Thank you, Fraz. Yeah, as you mentioned, do put in your questions in the chat box, and if you do want to speak, just make a mention of that. And you can also raise your hand once we start the Q&A session as well. So next up, we have Basit Khan from Kinetic Tax. Basit, are you there? I think we may have lost him temporarily. So what we're going to do is we're going to go to Seema Siddiqui from Ready Siddiqui, if you don't mind, Seema.
That's all right. Hi. Assalamu alaikum, everyone.
Alaikum salam.
Can you all hear me?
Yes.
My name is Seema Siddiqui. I'm one of the partners at Ready Siddiqui. We've been a very long established firm of chartered accountants. So most of the stuff that we do on a day-to-day basis revolves around tax mainly, although we do a lot of accounts and preparation type of work as well. But today we'll just concentrate. I would like to mention a few things about tax planning and tax-related suggestions that could help people around this time and the topic that we are about to discuss. I know Fraz mentioned will planning and why will planning is so important from a legal perspective, but will planning is also extremely important from a tax perspective, because after all, if the state is above, between husband and wife, jointly owned state is above £650,000, there is inheritance tax. But then we also have some additional nil rate band allowance for a main home, taking the state value up to £1 million. So anything above £1 million, we're looking at an inheritance tax liability on a second death at 40%. And so that's quite a huge tax position for most people if your estate is above £1 million. So that's the little bit on inheritance tax, but we can go into a lot of detail as to how via will planning, via some lifetime distribution of assets, and that one can actually help reduce your estate so that you are not putting your family in a position post-death where not only they are having to deal with the grieving process, that they also have now having to deal with a huge inheritance tax liability. And that's why we say that it's useful and it's important that during your lifetime that you should start considering some sort of planning in terms of distribution of your estate via trust planning. My colleague Basit Khan is also in the panel and he's the expert on trust planning. I'd rather want him to discuss into more details about trust planning side of it. But the two are actually very connected. Trust planning is connected with income tax planning. So when we are talking about trust planning, especially lifetime trust planning, which is normally discretionary trust planning or interest in possession trust planning, we are trying to separate some of these states, some of the assets away from the ownership of in most cases, husband and wife or parents. So by doing that, we can remove a certain element of income in the hands of the next generation. And that's how trust planning interacts very nicely with income tax planning. So what we are trying to do here is every individual has a personal allowance of now at this moment in time £12,500. So via the trust, we are able to recommend a way of planning whereby every individual, every beneficiary in the trust can be entitled to an income of up to £12,500, whereby that income is no longer now being subject to tax at the higher rate at the hands of the parents. So this is one very interesting planning whereby it interacts very nicely with inheritance tax planning, as well as gives you income tax planning during lifetime of the parents. At the same time that we do income tax planning, we also advise our clients on taxes. There are many different types of taxes. We all know that. This inheritance tax planning, which happens on death, income tax planning is throughout life. And then there are various events where capital gains tax planning can come into crystallization as well. And one of the times that when we see capital gains tax is during the time of our planning when we are trying to create trust structure. So instead of actually giving estate away to the next generation directly, and this is where again Basit will give you more information and advice, we do via trust planning. And the reason why we do via trust planning is because trust has the benefit of the advantage of holdover relief. So any gain that crystallizes as a result of transfer of the assets from the individual or joint ownership of husband and wife to the trust, the capital gains aspect of this event can be held over. So the capital gains tax that would normally be subject to capital tax at either 28% or 20% can be rolled over and not subject to tax. So that's another way of mitigating tax. It's not tax avoidance. It's planning, and it falls under mitigation, whereby within the law you're allowed to defer the tax until the next capital gains tax event takes place. Sometimes the next capital gains tax event may never take place because if the individual, the person who passes away or gives the assets basically into the trust, passes away, then the capital gains tax dies with death. So that's just a little bit on income tax planning via some form of distribution of estates through trust planning and capital gains tax planning. And I've also said earlier on how will planning is so important so that we can hopefully reduce the inheritance tax impact on second death. I hope that was of some use, and I hope Basit will come back now to discuss a little bit more detail about trust planning.
I think we've actually lost Basit. Basit, if you're there, just let us know. But in the meantime, we are going to ask Sheikh Haitham to say a piece also. So Sheikh Haitham, over to you.
Yeah. Okay. Bismillah ar-Rahman ar-Rahim. Alhamdulillah wa salatu wa salam ala Rasulillah. Welcome everyone. Yeah, my name is Haitham al-Haddad, and I wear different hats. I mean, not physically, but I'm involved in different projects within the community. And one of them is this, which is relevant to this discussion, the Islamic Council of Europe. What do we do in this organization, which is based in London, in Mariam Center above East London Mosque? We do a wide range of activities for the Muslim community. We provide counseling in social aspects, sometimes even political aspects, financial aspects, and so on. We deal with marriage problems, all types of marriage problems, conflicts between husband and wife, divorce issues, 3 divorces in one go, sisters who want to end their marriage by means of disputes over custody of children, and you name it. Also, we deal sometimes, let us move on quickly. We also deal with financial issues, either provide Sharia compliant for certain projects. There are so many people who approach us, they want to know whether their projects are Islamic Sharia compliant projects or not. It will be very, amazing to know that one of the non-Muslim companies, they approach us, and they are providers of one of the main electronic many caps in London. We also provide help to people in terms of how to divide their assets. Many people have confusion regarding that and how they can divide their assets from an Islamic perspective. And sometimes, or in many cases, we deal with financial disputes between partners, whether business partners or even married couples. We also provide some other services, fatwas, to the Muslim community. Now, what I want to say about the will, brothers and sisters, I believe that it is obligatory upon every single Muslim to write his will. Okay? And why it is obligatory? Because there are so many things that cannot be solved except if there is a will of the individual. And we might go through some of them quickly now. That will, okay, first of all, the Prophet ﷺ said it is not befitting for any person who has something to bequest to stay overnight or to stay 3 nights without his will written next to him. So the person who narrated this hadith, Ibn Umar, one of the companions of the Prophet ﷺ, said that I never stayed for 2 nights except with my will written next to my pillow. Now, in the West here, in general, because I can see that there might be some non-British people, Western, from Europe, in the will, you need to state a few things. And that's why we believe that it is obligatory to have your will written and accessible enough. First of all, you need to, of course, to declare your faith. Secondly, you need to write how you want your janazah to be processed. There are some revert Muslims, they don't have a will, they did not have a will, they did not have relatives, Muslim relatives, and as a result of this, they ended up by being cremated. And there are a few examples like this because the first of kin or their relatives wanted them to be cremated. And actually, there was a case of a Muslim brother recently, 2-3 weeks ago. One of his, I cannot mention the details, but one of his relatives who declared himself or herself to be a non-Muslim, he claimed that their father or this relative is not Muslim and they want him to be cremated. What saved him is a will that was written some time ago. So this is another thing. The third point that you need to include in your will is who is going to look after your children if they are minor after you pass away. Sometimes if you don't have this, then the social services might be involved in order to look after your children, and then maybe your next of kin or parents or other relatives, they have to fight a long battle in order to be able to have maybe to have your children with them, or maybe to have a say in the way those children are raised up. The fourth thing that needs to be written is your assets. How do you want them to be distributed? Brothers and sisters, the legal system here is not Islamic. And therefore, if a person died without a written will, his assets will not be distributed according to Sharia. From an Islamic perspective, as a Sharia scholar, I say that it is a sin, a major sin, actually. It can be a major sin on the person who leaves assets to be distributed according to Sharia, yet he does not take enough means to make sure that those assets are distributed according to Sharia. Why? Because he is changing the law of Allah Jalla wa'ala that was stated in the Quran. And alhamdulillah, in this country, if you write your will that your assets to be distributed according to Sharia, then in most cases, this will be honored and your assets will be distributed according to Sharia. Moreover, we have witnessed that those people who do not have a written will to indicate, to state that clearly, there will be huge disputes between their children, the children and the wife and their other relatives. Some of them, they want the law of the land to be implemented, and some of them, they want Sharia. Some of them, they might disagree that the boys will get double the shares of girls, and so on. So please make sure that that is written. The last thing is, it is good, I strongly advise, and I can give you so many cases and the stories of people who passed away and their children did not honor their will, and their children were jumping on their money, forgetting about their parents, forgetting about the loved one that they lost. I strongly advise that you write in your will that 1/3 of your assets to go to a charity that you name. And obviously, as Brother Fraz mentioned, that you need to state in your will the executors. Yeah, I also recommend that you might set a small committee, like 3 people. Maybe they play the role of executors, but also they play the role of looking after your family and assets in case of there is a dispute. Especially if you have minors or young children, then you don't need one to be the guardian of them and to decide whatever he wants to decide or she wants to decide. Maybe you need a committee from your close relatives in certain circumstances. The last thing, maybe the Brother Fraz might speak about, or might need to speak about, the power of autonomy, because sometimes if you don't have this person to act on your behalf, you will struggle, or they will struggle, your relatives will struggle in withdrawing the money, in doing certain things, because there is no power of autonomy. Jazakumullah khairan. I hope that it is clear. I welcome your questions.
Thank you very much.
Follow on that very quickly, because I did mean to mention it. I'll just take literally 1 minute. Sheikh mentioned an extremely important point, and that is the lasting power of attorney. So a will is a document that cites your instructions, and it in a weird way, that document comes to life when you die. Okay, whereas a lasting power of attorney is a document that you put in place that gives an instruction to somebody that will follow your instructions, not when you pass away, but when you are mentally incapacitated to make that decision. Yeah. Okay, so that situation could come about, God, horrible circumstances like a car accident, or even in the environment that we're in now. If someone was to contract this horrible virus, and then you're incapacitated, unable to reach your bank, for example, or unable to process certain instructions. And there are 2 types. Okay, there is one for finance, and there is one for health and well-being. And when you have your marbles, so to speak, when you have testamentary capacity, you would have that document put in place and it's registered at the court. So, for example, I would appoint my wife to be the person who would make decisions on my behalf in relation to my finances and my well-being, and then that's registered at the court. And there are 2 documents registered at the court, and there's a registration fee payable for that. Okay, to do it after the event, after you have lost that capacity, is then a very lengthy, very expensive process. So it's another form of sorting your affairs out before you're unable to. Okay, that's all I wanted to say on that. Any other questions on that, I'm happy to take them.
Thank you very much. So we have Basit who's back on. So Basit Khan from Kinetic Tax.
Thank you very much, Kajal. And my apologies. It's the internet gremlins. They always end up messing up the computer. And bless the team at Saracens. It's such a popular subject. We've reached capacity, is what's happened, and that kept me out all this time. But I think somebody's kindly made way so I could come back and speak. So it's great to be back. Thank you for the introduction, Kajal. I'm, of course, Basit. I'm the Managing Director at Kinetic Tax, and we're going to specialize in all kind of funds and joys of minimizing tax liabilities, inheritance tax in particular. Now, with respect to Islamic distribution, I know Sheikh gave a lot of details, and Fraz, everyone spoke in great depth about the Sharia distribution. Now, the key thing is, of course, when it comes to inheritance tax, and forgive me, Seema, if you've already covered this, when it comes to inheritance tax, it's not necessarily the most tax efficient thing to do. Now, of course, the priority is we want to please Allah, we want to please our Creator, and that always takes priority over any taxes. But at the same time, why should we pay tax when we don't have to, right? So the key thing should be is that when you are drafting your will, do take into account tax rules. Now, essentially, you've got an allowance of £325,000. That's the only amount that can go tax-free to any one individual. Now, if you think of the Islamic distribution, if you're giving, 12.5% to your wife, that's the only amount that is basically tax-free. Remember, gifts between husband and wives or spouses, essentially, are always free of taxes. So as far as the Sharia distribution is concerned, that means only 12.5% of your assets can pass on tax-free. After that, the first £325,000 is tax-free. Anything after that is liable to tax. So all I would say is that if you are writing a will, do ensure that you look to structure it in a tax-efficient manner. Now, a neat way we always find is by utilizing trusts within the will. You can create trust during your lifetime, and sometimes we always say do planning during your life to minimize liabilities. But within the will itself, if your estate is more than, say, £1 million as a couple, I would say that you should look at having a trust in your will whereby your estate on death is going into the trust. Now name all of the beneficiaries, all your children, your spouse, parents, if they're alive, as beneficiaries, and leave a set of instructions to the trustees to say, I wish to distribute according to Sharia. These are the rule, or this is how I want you to apply that. You could even write out what the specific shares are per individual. Now that way, if structured correctly, the trust will, inshallah, ensure there's no inheritance tax. The instruction to the trustees will ensure you adhere to your faith and your estate is distributed according to your wishes, according to Sharia. That would be a good way to balance that. So my key advice is do take into account the allowances. Remember, 325,000 being the allowance that you have. Interspousal exemption means between spouses, there's no tax. But distributed according to Sharia could result in IHT, but plan with trust. That's the key thing.
Thank you, Basit. Very useful. Right, so we are now done with everybody telling us a little bit about their areas. It's time for those questions. So we've had a fair few questions in already, and we are kind of looking through them, and there's a few repeat questions, so we will answer them probably as soon as we possibly can, just so that those questions are actually answered. Remember, whilst we're going through this, the experts will be giving answers, and if you do have further questions, just feel free to raise your hand if you want to speak to them. It'd be good to hear people's voices, and also just put a message in the chat box to Saracen Solicitors as well, so we keep those questions coming in. So our first question, I'm going to just get straight in. It is a question here which says, I'll read it out. I used to get money from child tax credit and child benefit. Most of it went on kids, but in the beginning I saved a couple of £100. I recently bought a house and nearly all of it is from my money and my mum's. Can my wife claim any share on this property because we used to get tax credit? And I think this is probably geared towards one of our tax advisors. So Basit or Seema?
So could you just repeat the question? My connection is still playing around a bit.
Sure. It's I used to get money from child tax credit and child benefit. Most of it went on kids, but in the beginning I saved a couple of £100. I recently bought a house and nearly all of it is from my money and my mum's. Can my wife claim any share on this property because we used to get tax credit?
Ooh, that's a good question. A very convoluted question. So if I understand correctly, there were income. So I guess that the tax credit belongs to you as a parent, right? So the way I always look at these things is who is the person who owns that asset, and that's the way you've got to look at an asset. That if when you've purchased something, are you considering it to be joint between yourself and your spouse, or is it yours by yourself? Now, when it comes to child tax credit, my understanding of that is that that's something for you as parents. So if you've used that money to buy any form of asset, I would say that that proportion constitutes a joint asset. And really, you should be treating that as, when it comes to distribution, that essentially it's an equal asset and then distribute that accordingly.
That does make sense. And I'm just asking.
Can I say something?
Yeah, go ahead.
Yeah, I think the issue here, although I am not a lawyer, although part of what I studied is law, yeah, and I like law very much, or studying law. It doesn't mean that I like the law, okay, in all aspects, and there is a difference liking studying law and law. Yeah, and I like lawyers, by the way, and I think they are doing a great job, and they should be doing a great job. And they should lower their, rates a little bit. Okay, this is a side issue. Now, we don't want to criticize Saracens here directly, but if I may say that the issue here is how the law will prove that this money that was used to buy this property came from the tax assets. This is the predicament. This is the question. Because I came through this question number of times, and it will be very difficult to prove that, well, this person or my spouse or ex-spouse, he bought this assets from the tax credit. Yeah. So once you receive the money, you received it. Who will be able to chase the source of this money? Yeah, there's something to consider. Yeah,
definitely. Okay, we actually had a hand raised, so I'm going to go straight to them before we ask the next question. It is Farah. Did you want to speak to one of our advisors?
Assalamu alaikum. Can you hear me?
Yes, we can.
Oh, assalamu alaikum, yes. I'm in a bit of a bind because I want to obviously to prepare a will, and I was told I should do a will trust. But I have a disabled son with autism and other special needs, and I was advised by a special needs charity that I need to set up a disabled trust for him in my lifetime. But then who writes the will? Because if I need a Sharia will, then that would be like an Islamic company writing that. They may not necessarily specialize in disabled trusts. So I don't know how to go about doing that. Who do I have to get an English company to do the disabled trust? Do I get a Muslim country to do the will? And then how do they write it in such a way that it includes that? Makes any sense?
No, that does make sense. I'm going to let Fraz, did you want to start with the answer to that one?
Yeah, so the answer to your question is the will would need to be, if you're after a Sharia compliant will, then the first place is someone like us that will for you, right? So we have the experience of crafting English legal wills with Sharia. elements to it, or a fully Sharia compliant will. There are two things that I would do though, and it's good that you've come here because you've got the right experts around the room. So in order to set that trust up, I would speak to somebody like Basit in order to have that built into the will. If it's a simple lifetime trust, then it's just a question of having that built within the will, or having that trust built outside of the will, possibly. Well, I'd veer to Basit for advice on that. And then once that will has been drafted, I would then return back to somebody like ICE, Sheikh Haitham represents ICE, in order for compliance or an endorsement to confirm that that will is properly Sharia compliant, to give you that peace of mind, and they provide that service, right? So someone like me would draft in tandem with someone like Basit, who would then advise on the trust. Once that document's drafted, we'd then hand over to ICE and ask them to endorse and confirm this Sharia compliant. And if it isn't in any way, they would then revert back to us. Does that answer your question? I don't know if, Basit, if you want to sort of intervene there in respect to the trust.
Yeah, absolutely. I mean, what you can do, you do have vulnerable persons trust. So
that's the one. Yes, that's the one I'm looking for. Yes,
suggested.
Yes.
Yeah.
And I need two because my daughter's also disabled. So.
Right. No, that makes sense, and that's probably recommended. Now, essentially, what a vulnerable person's trust is akin to a discretionary trust, which is essentially you have a trustee and assets and income is distributed per their discretion. Now, what you can do is you can set up a vulnerable person trust now. You only need to settle, say, £10 to open up a trust. Essentially, for all intents and purposes, right now, it would be a dormant trust. In your will, you can stipulate whatever the shares are for your son and your daughter. So again, if we're saying 2 shares to son, 1 share to daughter, in the will, you could say, I'm settling this into this trust. So let's choose your name. If you call it the Farah Family Trust, for example, you can then say in the will, I'm leaving this inheritance for my son in the Farah Family Trust. That way, it will then be a trust for the vulnerable child, and they will be able to inherit via the trust. So the will essentially transfer the asset into the trust which you've already created for their benefit.
But that would be on death, though. It wouldn't be now. And I was told I need to have a vulnerable trust now.
Yeah, so remember, that will be a dormant trust right now. So whilst it's created, it essentially means that your trust has come into effect, but there's nothing in there. As in, you like I say, you'd probably settle, say, £10 and maybe open up a bank account for the trust. And that way the trust has come into effect. But you wouldn't literally transfer an asset in there. I mean, you can do if you wanted to. There's nothing stopping you from doing that. But again, just from a pure inheritance perspective, you could have that as a dormant entity, sitting on the side. It kind of supplements the will. And then in the will itself, you would say, I distribute according to Sharia, and then it would distribute into that trust for you at that point.
Can I make a point here?
Sorry, because I wanted to have a follow-up question. Sorry.
Sure. Go ahead.
Oh, sorry. Yeah, no, sorry. Sorry, I was told that the main reason for wanting to have a vulnerable trust now is that if he's unable to work, then if he did have money, then I don't want it to impact on his on benefits.
I think, are you trying to do this from an income tax point of view? You're trying to distribute income to your children now during the lifetime.
Not income, but if they
protection,
get now,
protection of the assets.
Yeah. So if they get given money now, so say they get gifted money, so then that would, if my son couldn't work, then that would impact on his care and also his benefits, social care and benefits. So that's what I'm trying to seeking to protect at the time. And obviously, when I die, then the inheritance aspect as well.
Okay, yes, you can have lifetime trust as well to protect the assets.
So my understanding of so are you there sort of qualified or specialised in doing disabled trusts or not?
Yes, we can help you. Basit and I can help you, and also working with Saracens, we can help you create a vulnerable trust. And this is not just a trust for protection. It can also be a way of planning for income as well. So your children could receive income from the trust and basically be subject to tax at the basic rate band. So it's actually quite a nice way of income tax planning as well.
Thank you, guys. Farah, I hope that answered your question, because we've got.
I just had one. Oh, so just one other question. Sorry, I'm having one other question. Sorry, I'm having a problem trying to kind of find trustees, because one of the people I approached said that if they agree to be a trustee, then the assets in the trust would belong to them, and that could affect their tax position or something. Is that true or not?
I think Fraz can answer that question.
I think it's more a question for Basit, to be honest. Again, I think it's in terms of liability there, the question is often raised, and you can appoint professional trustees. There's a cost for that, but in terms of their personal tax position, I mean, I would ask someone like Basit or Seema that question. I don't think that's applicable, right?
No, I mean,
No.
a trustee is just holding it as a trustee for the benefit of either the trust or the beneficiaries. So the trustee is responsible for accounting for the trust, as in submitting the accounts for the return, but it's not assessed on them personally. But as Fraz said, if you are struggling with trustees, the thing we always say about trustees is appoint trustworthy people, because they're essentially responsible for that asset, and appoint professionals, because the professionals would always work in the best interest of the beneficiary.
Thanks, Basit. And Farah, and as anyone else, actually, if you do have like really detailed questions, we will be sending you our contact details at the end of this, so we can have that detailed conversation. I'm just kind of mindful that we have so many questions to get.
Yeah. Thank you. Thank you
Thank you so much, Farah. Right, so we had another raised hand, and this name, I do apologize if I incorrectly say it. It's Nemni Azafor. Are you there?
Hiya, can you hear me?
Yes, we can.
Yeah. Assalamu alaikum, everybody. I've got a question. So my husband and I, we've got 2 adopted children. And I think in my case, if I was to die before my husband, I'm a convert to Islam, so I don't have any other relatives who are Muslim. So he would get all of my estate, but I don't know what would happen if it was the other way round because of my children. How much could I give to my children? How much can he give to our children? But they're not obviously inheritors in the Islamic sense.
Experts?
I think this is a question for Sheikh.
Yes.
Yeah. Okay. So you have biological children, and
no biological children, just 2 adopted children.
Yeah. Okay. 2. Yeah. The matter is easy. If between you and your husband, you will inherit 1/4 of his. Does your husband have children from any other marriage?
No.
Yes or no?
No, he doesn't. No.
Okay.
These are our only children. Yeah.
Yeah. So you will get 1/4 of his assets, and he will get 1/2 of your assets. Okay. And if the rest, you can you can have 1/3 of your assets, and he can also have 1/3 of the assets written to be distributed to your adopted children. Okay. And outstanding balance needs to be distributed in a different way. That needs maybe detailed discussion to see who are the relatives who are living at that time, etc. Yeah, but generally speaking, you will inherit 1/4 of him. Yeah, he will inherit 1/2 of your assets if you die before him, and both of you can have in your written wills that 1/3 to go to your adopted children.
Jazakallah Sheikh, I don't have any other Muslim relatives except my husband. So if I was to be widowed, what would be the case then?
Okay, so you don't have any other relative?
I don't have any Muslim relatives. My relatives are all non-Muslim.
Yeah, well, I need to get back to you about this question because this is a very, very rare question. You will be leaving your husband, who's obviously Muslim, and your adopted children. Yeah, so your question is, can you, after giving 1/3 to your adopted children and 1/2, yeah, there will be an outstanding balance here. Where is this outstanding balance need to go? Yeah.
Yes.
Okay.
Yeah.
Okay. I need to get back to you. Okay, regarding this. Yeah. You might contact ICE. The brothers, they will provide you with the contact details of ICE. ICE stands for Islamic Council of Europe, and then we can deal with your query. Yeah.
Thank you very much, both. Thanks for that. Okay, we have another question. This one is an LPA related question. It's, can I make an LPA if I have dementia? And this question is for Abtin.
Okay, so the test for making an LPA is whether you actually have mental capacity. So even though an individual has dementia, it doesn't necessarily mean they lack the capacity under the Mental Capacity Act to make an LPA. So it really just comes down to conducting an assessment, and we or the certificate provider would need to just establish that the donor, i.e. the person making the LPA, still has the required mental capacity to understand what it is they're actually doing in terms of making an LPA and the consequences of doing so. So yes, in short.
Great, thank you. Okay, so we have another raised hand, but what I'm going to ask you to do is, just because we've got very restricted time, and it's actually 23 minutes past, because we have so many questions, what we're going to do is we're going to extend this event to 6:45, because we know that everyone needs to go and prepare for food or prepare for iftar. So we will extend for another 15 minutes. But if you do want to raise your hand, if you could kindly just restrict that, and I hate to ask, just kindly restrict it to just the one question for now. And what we can do is we can take this offline and we can have proper detailed one-to-ones with the experts, and you'll get all their contact details, so you're not missing out on anything. So I'm going to ask Faisal, you raised your hand. Did you have a question?
Assalamu alaikum, everybody. Yes, I guess my question is quite simple, hopefully. It's the first time I'm looking into sort of anything regarding will writing, and I've heard from a number of the panel experts of different elements to consider. But in terms of a sequence of events, I mean, do I take tax planning the first thing, will writing the first thing, looking into trusts? I mean, I guess the question is, where do I start and in what order do I take the steps through to get to a position where I've got a sort of a Sharia written will?
Yeah, it's a very good question, actually. Fraz, we actually did something like this today. So did you want to start the experts off?
Yeah, of course. Assalamu alaikum, Faisal. Interesting picture you got behind you. Is that Manchester United? What is that?
No, it's Lancashire FA.
Okay. Okay, great. I shouldn't have asked. Okay, so this is from an Arsenal fan. I'm probably now alienating myself. So first of all, the way that we do this, right, is to kind of make the process a little easier, is we have many lawyers will have a standardized questionnaire, right? And we'll send that to the client, and it will get the grey matter going a little bit. It will ask you the obvious questions, your identification and your family members, but it will get you thinking about things like, for example, your assets and all that kind of stuff. So we get that list, right? our question is quite detailed. So we will ask you, for example, what would happen to your body if you were to pass away? Say, for example, I don't know, let's say you were on holiday somewhere in Turkey for a vacation. What would happen if you were performing Umrah or Hajj? What would happen if you were on a crazy weekend with your friends in America, Vegas or something like that? Not that you would go there, but do you understand? So we would ask these questions. And by the way, there is a Sharia answer to this question. Sheikh will know that answer. But we would ask all these questions. Right? The main starting point from there, or the main point from there, is to ascertain what the asset value is and the ownership of certain assets. My short presentation, and then we would liaise with someone like Basit and Seema, and what they would then do is then look at that, some kind of outline on the kind of restructuring or trust structuring or kind of various tax efficient ways of being able to hold that. And they would then, and I'll hand over to them. I mean, that's the process that they would then follow back with advice for us, and then we would draft. Seema, do you want to just add a little bit to that and maybe hand over to
Sorry, go ahead, Seema.
No, that's okay. Carry on, Basit.
I was going to say, actually, I think Fraz was quite thorough. I'd concur with his advice that, when fill out a questionnaire, then we know exactly what the estate looks like. And obviously, when you're drafting the will, we can take into account all the tax planning needs at the same time. So 9 out of 10 times, it's, will is part of an overall piece of planning. Is what we say that, the will is the essential document that's needed. But when you are looking into your will and delving into how do I avoid inheritance tax, and obviously all the tax planning comes around it. So both go hand in hand, essentially.
Thanks, Basit. Hope that answers your question. We are going to move on to another question, which we have. And this is one that's written. So if I have a Sharia will prepared, but get divorced with my spouse, what happens? Sheikh Haitham, are you able to answer that question?
Yeah, I think she's asking. She had her will written, okay, Sharia will, and then she was divorced from her husband. Yeah, is this the question?
Yeah, they had a so she had a Sharia will and then got divorced. What happens?
We need to look at the contents of the will. What did she write? For example, had she written in the will that my husband will receive 1/2 or 1/4, it depends whether I have children or not. Yeah, so we need to check that, and maybe she needs to change the if that is there, because the man is not her husband anymore, so he will not inherit from her as a husband. Yeah.
Cool. Thank you, Sheikh Haitham. We have a raised hand, actually. It is for somebody called H. Are you there? I think you're on mute.
Yes, salam alaikum. Yes, I am here. Jazakumullah khair for doing this. Okay, I have two questions. The first question, is it possible to write your own will and just having two witnesses, and you don't need but obviously I have two boys and everything is going to be split between them, and my husband passed away. So this is what my plan. So is it possible to write your own will? Without lawyers, sorry. And the second one is, what is the inheritance tax? Can you explain to me in basic words exactly how much tax is involved in here?
Yep, thank you, H. So for your first question, we're going to ask Fraz in a couple of minutes to tell you what that answer is, and then we'll move on to one of our experts as well, who can hopefully wrap that up for you in a short summary as well. So Fraz.
Okay, I got the hint. Okay, you want to be quick. Okay, short answer is H is that you can draft it yourself. We would thoroughly not recommend that, because if your estate is very simple, and what by that I mean underneath the tax threshold, and you're just saying I list your assets and I simply wish to distribute to Sharia, possibly so, right? There are line, but I alluded to the ownership of property. I alluded to tax structuring, and there may be other issues, for example, guardianship and things like that. Where it starts getting complex, then I would recommend probably that you don't, and that you'd at the very least speak to somebody, get some guidance, if not have the lawyer draft it. But if it's, let's say, for budget reasons, for example, there are templates online, and so the answer is yes, you can.
Okay, Jazakallah khair.
2 minutes?
Thank you.
Okay.
Yeah.
And now on to your inheritance tax question.
Yeah.
Seema, Basit, did you?
Yeah, I'll answer. I think it was very useful that you asked the question about the writing of the will. And I like the answer that came from Fraz, because what Fraz is trying to say to you is when you are writing up the will, that's an opportunity for you to also do some planning. Right? And it's very easy to think that, okay, fine, I'm going to write the will and distribute my estate to my 2 sons. But at the same time as that you're writing the will, when you're doing the planning, then you can start looking at the size of your estate. And if you are, and you ask the question about how much tax, inheritance tax, you're going to pay. If the estate is worth a certain amount, at this moment in time, the nil rate band, which is outside inheritance tax, is £325,000. You also inherit your husband's, your deceased husband's nil rate band as well, which is another £325,000. So your estate up to £650,000 is not subject to inheritance tax. Plus, if a main home is involved, you get another £175,000 of nil rate band. Right? So any amount over and above 650 plus 175 is subject to inheritance tax. So now is the time to start thinking about planning, because don't forget, sadly, your husband is not here anymore. So if interspousal, if your husband is alive, then Basit explained earlier, then you can take advantage of trust planning within will, and you can take advantage of interspousal exemption and basically distribute estates that way around. But because that is not available, more than ever before, right? Although it's tempting for you to write your own will, it's more than ever before. It's very important that you get your will written by an expert. So the legal side is covered by lawyers, and the tax planning side is covered by an expert accountant.
Okay.
Can I just add to that on the DIY wills point, because I know a lot of people do tend to do this, and they forget the fact that a simple mistake on a will can obviously render the whole thing invalid. And a key benefit, which is something we deal with a lot in the dispute resolution department, is the fact that whilst you may have a will, it can always be challenged. And when someone does challenge a will, quite often the key evidence or witness where the will was professionally drafted tends to be the lawyer who drafted it, who will obviously have records of the meetings they've had with the clients, and they'll be able to, they will play a big role in settling the dispute and hopefully bring it to an end quickly to avoid the estate being eaten up in legal costs.
Okay. Jazakallah. Jazakumullah khair.
Thank you all for that. Next question, Basit, you actually, not Basit, sorry, Abtin, this is for you. My mother has dementia. She's not lost all of her, not all of her abilities yet, but has good days and other days where she's quite confused. Can we, as her daughters, set up a lasting power of attorney, and what's the process and cost?
Sure. So the lasting power of attorney is something that has to be set up by the donor. The daughters can obviously arrange the appointment, and quite often it is the case that people with dementia have good days and bad days, so we can always conduct more than one assessment to assess their capacity. And it's what I mentioned earlier, it all depends on the circumstances. If we're satisfied the person has capacity, then we can act as certificate provider and witness the LPA. If there is any doubts, we can always write to the donor's general practitioner, to the GP, and get some further details and medical records from them just to be satisfied. But it shouldn't be a problem.
Mm-hmm. Thanks, Abtin. Our next question is, it's a Sharia-related question, so this one will be for you, Sheikh. Is writing "my assets to be distributed in accordance to Sharia" in your will enough for it to be distributed in this manner?
Yeah. Okay. I think this question has to be forwarded to Fraz. Yeah. But from an Islamic perspective, see, brothers and sisters, please pass this message to others. From an Islamic perspective, once the person dies, he doesn't own his assets. So whether he has written a will or he did not written a will, this is from an Islamic perspective, his assets have been given already to the legal heirs, except the 1/3 if he has written something about it. But if he did not indicate anything about the 1/3, the minute the person died, then the assets will go to the legal heirs, yeah, the legal Sharia heirs. Now, why do we write a will? Because in this country, if you die, then your assets will be distributed according to the law of the land, not according to the Sharia. That's why we say you have to write a will. Okay. Now, this is my part to answer, but the second part now, Fraz needs to answer it. That is it enough to write?
Kajal, I lost part of the first part of that question. Do you mind repeating? I could listen to the Sheikh's answer, but could you repeat the question again? Kajal, can you hear me?
Hi, sorry, I was on mute.
Yeah, sorry, I lost the first part of the question. I was listening to the Sheikh's answer. I kind of gathered what it was, but do you mind just repeating it just for the sake of...
I'll do that. It's is writing "my assets to be distributed in accordance to Sharia" in your will enough for it to be distributed in this manner?
Yes. In English law, you have free choice to give to whom you want. So when you create that will, sometimes you hear these crazy stories on the news that the old lady, she left everything to the dog's home, right? So you have complete and utter free choice. There are different ways of drafting the Sharia elements within the distribution within the will. Some people hardwire the distribution calculations into the draft. Some people prefer just to make a simple statement that the assets are to be distributed in accordance with the Sharia. They may cite a school of thought. They may cite a scholar that would preside over any dispute or misunderstandings. But in answer to your question, yes, you can distribute as long as the document is validly executed. It has the various legal requirements I mentioned at the outset of this presentation, and it's legally valid, then yes.
Great, thank you. Right, so Nashir has a raised hand. Did you want to have a chat with the experts, or do you have a single question? Because we're just running out of time. Nashir? No.
Assalamu alaikum.
Oh, hi.
Oh, hi. Sorry. Yes, the question you've just mentioned now, that was my question actually, with regards to putting the note in with it being distributed in accordance to Sharia. So thanks for asking that one. Is it the case then that the executors have the responsibility of actually doing that then, in terms of apportioning it in accordance to the Sharia?
So the executors are the people or person who takes responsibility to follow your instructions.
Okay.
That's their legal responsibility, and it's actually it is a legal responsibility, right? So if you had cited in your will that the assets are to be distributed in accordance with the Sharia, and you've been very clear about all of that, then your executors must follow that instruction.
And I guess with regards to how do they check that that's been done accordingly, is that back to your question of putting trustworthy people down or the appropriate people down? Okay, cool.
Absolutely, yeah. And when you say they, I mean, I think you mean by the probate registry or the authorities, right?
Yes, exactly.
Yeah, yeah, of course. You would choose someone who you trust. There are very unusual circumstances where, well, it's maybe not as a class as unusual, but you can vary a will after someone's passed away. It's usually because of sort of complex tax planning, and sometimes it may be that someone says, "Look, we would like the will to be distributed in accordance with the Sharia," and they then introduce that after someone's passed away. I won't complicate it too much, but yeah, in answer to your question, the executor is the one that carries out the instructions, and whatever you say in your will, that's it.
Okay, thank you for that.
Thank you very much. I actually have a question for the panel. Because we're kind of getting closer to 6:45, would you mind extending it to 7 o'clock, or do you have to leave?
Actually, I have another live Q&A at 7 o'clock promptly.
Okay. So I guess what we can do then is we've got just a few questions, and we'll see where we go with that, and we won't go much longer.
If there are tax questions, I don't mind. I'll carry on.
Okay. All right then. So I'll have a check of that. In the meantime, we do have one question which has come up a couple of times, so I'm just going to ask that one. It is, apart from guardianship, is having a will still important when you don't have any estate or savings? And that one is directed to Fraz.
I would say so, yes, because you would want, so Sheikh alluded earlier on about your death, your faith, your burial, funeral wishes. What happens to your body if you pass away in a foreign land? If you don't cite exactly the specifics, it's not always about the money and how much I'm going to distribute. If you don't cite the specifics, then you're leaving it to the behest of the law of the land in which you pass away, which then becomes a little bit dangerous.
Mm-hmm. Okay, great. There is a follow-up question to that. Could you please clarify the Islamic assets distribution? Who gets how much? And do executors of the will and the power of attorney persons need to be family or Muslim?
Yeah. Well, the first part of the question is a long question. Yeah, we need to take a course in how the assets to be distributed. Yeah. But the second part, yeah, no need for the executors or the power of attorney to be your relatives. They say that, okay, they have to be people that you trustworthy people. That's it.
Mm-hmm. Okay, great. And I think this actually ties in with that question, or we might have actually answered that question. It says, Salam, can we please elaborate a little more about executors and who could be an executor? Do they have to be anyone other than the one who may be included in a will, for example, a wife or brother? I guess it's up to you, but I'll leave that for the experts to answer.
I mean, anyone can be an executor. You can even name a beneficiary. It's entirely up to you. You can appoint a professional. You can have more than one executor, so they can have to make decisions jointly. And obviously, if they do anything wrong, they're personally liable. I don't know if anyone else has anything they want to add to that.
Mm-hmm.
I agree with that.
Yep. Okay. And we have the next question is a tax-related question. It says, how can I gift a property if there is a mortgage on it? It's for one of our tax experts.
Absolutely.
Yeah, okay, Basit.
Very good. I say with great difficulty. With great difficulty. The issue is if you've got a mortgage in place and you're trying to gift, obviously you need lender's consent. It's very unlikely a lender will say, yep, I'm happy for the property to go to your son. Now, key thing to point out, let's say even if you did get lender's consent, you have a tax implication. You've got stamp duty, which is liable. And it's often one of those things which people aren't aware of or don't realize. But any gift where there's a mortgage, that mortgage amount is deemed consideration. And then that amount, let's say it's, I don't know, £200,000 is the mortgage amount, that amount becomes liable to stamp duty. So In theory, you can gift a property which has got a mortgage. The other thing I would say is if you are thinking of gifting a property, also be aware of capital gains tax. There's a lot of tax implications when you are making gifts. If it's an investment property and you try to gift that directly to your children, you will pay capital gains tax. It's a deemed disposal as far as HMRC are concerned. There's a misconception, again, that if I gift without charging anything for it, I shouldn't have any tax. Wrong. It will still be liable to tax. That can be avoided, again, with trust planning. So do be careful on that. Gifts can be made, but there are a lot of tax implications in the process.
Thanks, Basit. Our next question is, what are the main limitations of a Sharia compliant will?
I think this question is maybe a farewell for me, okay, before I leave. Well, see, the key thing is you cannot redistribute the assets, yeah? And please, I want to say this, brothers and sisters, as we said, once you pass away, you have no control over your assets whatsoever. Even if you wrote something against what Allah Jalla wa Ala have stated in the Quran, then from an Islamic perspective, what you have done is invalid. And it is a sin upon the executors to do so, even if it is your will, because it is not in your hand. It is also a sin on your legal heirs to accept that redistribution, okay, because they feel, sorry, let me make it okay, more accurate. Unless all of them agree to the redistribution, yeah, then this is as if they have taken their shares, but they have gifted what they have taken to others based on your wish. This is how it works. Other than that, it is haram for anyone, it is a sin for anyone to change what Allah Jalla wa Ala has stated in terms of the distribution of the assets of any deceased. You have only control over 1/3 of your assets. And this 1/3 should go to anyone apart from your legal heirs. Yeah. So therefore, you cannot state in your will that I want my son, this particular son, because he was helping me, or because he was nice to me, or he lived with me, or he is not rich, to take more than other sons. Yeah. Or I want my wife or my spouse to take more, yeah, because they were very supportive to me, etc. This is a very delicate area, and many people make major mistakes in are distributed according to the Islamic law that was stated by Allah and His Prophet, by Quran and Sunnah. Yeah, and I think I need to leave, because maybe you have heard that the brothers who are arranging the meeting, they are contacting me. Yeah. Okay.
Thank you very much, Jake.
Live QA session with eyes, actually. So thank you very much for that. It was really wonderful, very informative. I benefited from that. Okay, and I think this should be repeated number of times. Saracen, thank you for that. Well done everyone. Well done for the host, mashallah. Okay, see you inshallah later. Salam alaikum.
Thank you, Sheikh.
Thank you, Sheikh.
Thank
you to all of our panel, actually. We are running out of time, but because we've got so many questions, we do want to do this event again. So we're going to ask our panel, each of you, to come back, and we will do this event again and make sure some more questions are answered. But for the time being, that's all we actually have time for. Before we go, I did want to apologize. We had a number of people trying to come into this Zoom event, but there was a technical issue with Zoom, so not everybody could log on. So we do apologize for that, but we'll make sure that that's sorted with Zoom for the next one. Now, as I said, when you after this event, we will be sending you an email. You'll get some information and you'll get contact details of our panelists. We are going to be doing the event again, so you will get another date for this, but feel free to have that conversation one-to-one as well if you've got those detailed questions and answers that you want. And that's it. So thank you all for attending, experts and attendees. It's been great, and have a lovely evening.